Imagine being fired just one day before completing your probationary period, only to discover that the termination clause in your contract was unenforceable. This is exactly what happened to Reginald Chan, and his case has sent shockwaves through Ontario's employment law landscape. But here's where it gets controversial. A Superior Court decision has once again ruled that the seemingly harmless phrase "at any time" in termination clauses is not only unlawful, but also violates the Employment Standards Act, 2000, ESA, rendering the entire clause void. This ruling, Chan v. NYX Capital Corp., 2025 ONSC 4561, highlights a glaring inconsistency in Ontario law, where some courts strike down such clauses, while others let them slide, at least partially. For instance, cases like Default versus the Corporation of the Townships of Ignis, 2024 ONSC 1029, and Baker versus Van Dolder's Home Team Inc., 2025 ONSC 952, align with Chan, while others, such as Jones versus Strides Toronto Support Services, 2025 ONSC 2482, take a more lenient approach. This legal tug-of-war leaves both employers and employees in a precarious position, unsure of where they stand. Reginald Chan, an employee at NYX Capital Corp., a real estate investment firm, was terminated just one day shy of completing his 3-month probationary period. He sued NYX for wrongful dismissal, arguing that the termination clause in his contract was unenforceable, entitling him to common law notice. NYX, however, believed the clause allowed them to terminate Chan without notice during probation. The court sided with Chan, awarding him nearly $45,000 in damages, a stark reminder of the financial consequences of poorly drafted employment contracts. The termination clause in question read, "Your employment with NYX may be terminated as follows. A. The first 3 months of your employment are probationary, during which time NYX may terminate your employment at any time and for any reason at its discretion, without notice or pay in lieu of notice, or other obligation. After you successfully complete the first 3 months of your employment, NYX may terminate your employment at any time without cause. Upon providing you with notice, or pay in lieu of notice, benefits continuation and severance pay, if applicable, and any other benefits or entitlements strictly required in accordance with the minimum requirements set out in the ESA. D. The company may terminate your employment at any time for cause, without any obligation to you on account of notice or pay in lieu of notice, severance pay, or other obligation, other than accrued amounts owed to the date of termination." The court ruled that phrases like "at any time" and "at any time and for any reason" directly violate the ESA's prohibition against employers contracting out of its standards. This aligns with recent decisions like Default and Van Dolder's, which emphasize that employers do not have an absolute right to dismiss employees. For example, an employer cannot terminate an employee as retaliation for exercising ESA rights, making such broad contractual language unenforceable. The court also cited Walksdale versus Swagan North America Inc., 2020 ONCA 391, which established that any ESA violation in a termination clause renders the entire provision void. In Chan's case, this meant the entire termination clause was set aside, leading to his $45,000 payout. And this is the part most people miss. This case isn't just about legal jargon. It's a wake-up call for employers and employees alike. Employers must consult employment law experts to ensure their contracts comply with ESA standards or risk costly payouts. Employees, on the other hand, should have their contracts reviewed upon termination to avoid leaving money or benefits on the table. But here's a thought-provoking question. Should employers have the flexibility to terminate employees at any time during probation? Or does this phrase inherently undermine employee protections? Let us know your thoughts in the comments. This debate is far from over.